welcome to this wonderful edition. This is LETILS 268th edition, wherein we are on the second leg of the discussion that we left halfway through a couple of weeks back. Today, the topic being the impact, if any, of the Harshad Mehta's case on Lieutenant Commander Pascal's case and on the power of various special courts to tender pardon to an accomplice at all stages. The more you look into it, the more confused one gets. And I'm sure that after today's discussion, we'll add upon to whether it's confusion or concrete understanding, but definitely to a better understanding of the profession, I'm sure. With all these eminent panelists today, we'll be addressing on this topic and to put things in perspective. I'll request Advocate S.K.Premraj. Before that, may I formally welcome Justice V. Ramkumar sir, Justice Basant sir, Justice Hariprasad sir, Justice Nagamuthu sir, Justice Mathew sir, and all of you wonderful participants who are part and parcel of this journey of discovery, empowerment, and enlightenment. Today, in the 268th session, let us address this issue of tendering pardon. So, Prem, for the introductory remarks.
Good evening, all. Now, today, I am supposed to state the facts of the two cases which is being discussed today. So, without much delay, let me go straight into the topic. Now, Lieutenant Commander Pascal Fernandez, that was a three-judge bench case, were three high-ranking government officials, along with a UD clerk, and four other accused. They were the contractors and one was the employee of the contractors. They were facing charges under various heads, which included criminal misconduct under Section 5(2) of the then Convention of Corruption Act of 1947. Then the UD clerk, he sought to be made as an approver, which petition was stoutly resisted by the other co-accused. The special judge, disregarding all these contentions, invoking Section 8(2) of the Criminal Law Amendment Act of 1952, he tendered an unconditional pardon, which was sought to be revised in the Bombay High. The High Court confirms, and the matter goes to the Supreme Court in special leave. In the appeal before the Supreme Court, the appellant, that was Commander Pascal Fernandez, he goes on to contend the key differences between sections 337 and 338 of the then CRPC of 1898. The section 8(2) of the Criminal Law Amendment Act of 1952, as we see, that is pari materia with section 5(2) of the Prevention of Corruption Act of 1988. Now, the second limb of contention in Pascal was that the powers of the special judge under Section 8, that was circumscribed by the considerations that underlie Section 540 of the then CRPC, which corresponds to Section 311 of the present code. And that, therefore, the special judge, he could not acquit one accused so as to enable conviction of the other accused, and that the special judge did not exercise his discretion judicially and properly. All these contentions were repelled and the appeal was dismissed. Now, the Supreme Court in that case goes on to hold that Section 7(1) and 7(3) of the Amendment Act of 52, that notwithstanding anything contained in the CRPC, the offences under the, at that point of time, we had sections 161 to 165A of the IPC and section 5(2) of the PC Act of 47, which shall be tried only by a special judge. So, in the case of an offence under section 5(2) of the then PC Act, under section 337 of the earlier Criminal Procedure Code, a magistrate with a view of obtaining the evidence of any person who was supposed to have been directly or indirectly concerned, or he was privy to an offence, he may tender pardon to him and he may get him examined under 337(2). And the magistrate, he was supposed not to make any further inquiry and he was to send the matter forth to the special judge under the provision of section 337(2) capital B. Now the provisions of section 337(1) that would thus apply at the stage of investigation or inquiry before the matter reaches the special judge. And when there is no such tender of pardon to anyone, then the case shall be forwarded for trial to the special judge, and his powers would commence after he has taken cognizance of the matter, cognizance of the case, and what is available to him throughout the trial. Now we see, when the case is before him, tender of pardon can only be by the special judge. But were the offences other than those under sections 161 to 165A of the IPC and section 5 of the then PC Act, when there is a committal by the magistrate under section 337(2)A, then section 338 provided that the court to which a committal is made could not only tender pardon, but that could also order the committal, the committing magistrate or the district magistrate to do so. So such a power was not available to the special judge because there was no committal when he has taken cognizance. Now we come to the second matter, which is the Harshad Mehta case of 2001, another 3-judge bench. Almost an identical objection was raised. Now this was a security scam, which was too epic in scale and the consequences. And the matter is still, some of the matters concerning this case, it is still pending in various courts in Bombay as well as in the Supreme Court. There, 2 separate applications were filed before the special court seeking for grant of pardon. And these 2 applications were supported by the CBI. The special court allowed both the petitions.
No, was it during investigation? Was it during investigation? Was it during investigation that application was filed?
Harshad Mehta
No.
during investigation.
Huh?
Harshad Mehta, that was during investigation only.
The judgment doesn't say so.
Yeah, no. It is specifically stated that it is during investigation. Yes.
Investigation. Okay.
Yes.
Which one, sir? Which one?
Dates are also mentioned.
Dates are mentioned.
That,
But
it is said
it is
that
not
it was
mentioned whether
pending
it was during investigation or
Yes,
after
specifically stated.
cognizance.
Yes, specifically stated.
Now, kindly see, we were at anyway, 2 applications were filed, supported by the CBI. Applications were allowed by the special court. Conditional pardon was granted. Now here, after grant of conditional pardon, the appellants, inclusive Harshad Mehta, they sought for revocation of the pardon. Now it was pleaded in this their applications that the pardon which was granted to the 2 persons therein were void and non-honest, and the main plank was the ground that the special court lacked jurisdiction to grant pardon. Now it was urged that the power to grant pardon, it was not expressly conferred on this court, and there was no question of inherent power in any court to grant pardon. And when no such power has been conferred on the special court ought not have done so. Both these applications were dismissed, holding that the special court had the powers to grant pardon. Now, the legality of this order was an issue before the Supreme Court. Taking note of various provisions of the CRPC of 1973, which we now have, in particular, Chapter 24, the apex court repelled all those contentions. Now, Chapter 24, that deals with the general provisions as to the inquiries and trials. Here we have section 306 and 307, which deal with the tender of pardon to an accomplice. 306 confers power upon the magistrate, and 307 on the court to which a committee is made. Now, section 308 provides for the consequences of not complying with the conditions of pardon by the person who has accepted the tender of pardon, which is either made under section 306 or be it under 307. And in Harshad, the court goes on to conclude that it does not necessarily follow therefrom that the power to tender pardon either under 306 or under 307, it has not been conferred on the special court. Firstly, but kindly see para 22 of the judgment. Now, this paragraph bears much relevance, wherein the Supreme Court goes on to hold that the special court may not be a criminal court as postulated under section 6 of the CRPC. Still, it's a criminal court of original jurisdiction. And the Supreme Court goes on to refer to A.R. Antule case, the constitutional bench of A.R. Antule, during 1984, a 5-judge bench decision of the Supreme Court, where Justice Desai is speaking for the bench. He had held that short of all the embellishment, the special court was a court of original criminal jurisdiction. And to make it functionally oriented, certain powers were conferred by the statute, setting it up, and except those which were specifically conferred or specifically denied, it has to function as a court of original criminal jurisdiction. And it was never hidebound by any terminological status description of magistrates or a court of session. Now, these were the exact words which were used. And under the code, that's CRPC, it will enjoy all the powers, and you see the words, it enjoys all the powers of a court of original criminal jurisdiction, save and except the one specifically denied. Then the bench goes on to analyze to see whether the power to grant pardon, it has been specifically denied to the special court. Now here we have I forgot to tell that we have a statute which establishes special court in that Harshad Mehta case called the Special Court Trial of Offences Relating to the Transactions of Securities Act of 1992. Now, here, this was a case where Harshad Mehta was defended by the iconic lawyer Ram Jethmalani, who took up a contention that the Special Court Act of 1992, it does not postulate committal of the case to the special court, and no provision was inserted in the act to empower the special court to tender pardon. So the impugned order which had granted pardon was one without jurisdiction. This argument, it is seen met with at para 35 of the judgment. There the 5-judge bench in A.R. Antule was referred to in para 22, and after referring to A.R. Antule, in this case, I think this is Justice Y.K. Sabharwal. Am I right, Justice Ramkumar?
Right, Sabharwal.
Sabharwal. He went on to observe that there could not be any controversy that there were no express provisions in the statute which excluded therefrom the applicability of sections 306 and 307 of the CRPC. And the court asks itself, can it be said so by necessary implication, and starts to analyze one by one. Here the next important paragraph would be para 51 of the judgment, where the court goes on to conclude that the code has been incorporated in the act by the application of the doctrine of legislation by incorporation. Now, the power to grant pardon has not been denied expressly, or at least by necessarily acceptable implications. Again, the court took note of the constitutional bench in A.R. Antule, goes on to further hold that it was never necessary to make a specific provision in the act which would confer a power on the special court to grant pardon at a trial or at a pre-trial stage. Because the special court, it's a court of original criminal jurisdiction. So it has all the powers of such a court under the code, including that of section 306 to 308 of the CRPC. as the same was never excluded specifically or otherwise. The following paragraph 52 also is highly relevant, where the court goes on to hold that the 92 Act, there is no provision which would negate the power of the special court to grant pardon. And the special court can grant pardon. Now, the power under section 307, that cannot be denied merely because there was no committal of the case is made to the special court. There the Supreme Court, in effect, approved the learned Solicitor General's argument that statutes were compared. And the Supreme Court goes on to say that other statutes, they could at the best be external aids to the interpretation. And further observe that to rely upon the omission of a provision which is contained in a different enactment, it has to be shown that the two acts were similar, which was not the position there. Pascal Fernandez is seen referred to, and the court at paragraph 55 goes on to conclude that it was unable to find any inconsistency or any provision which indicated expressly or by necessarily acceptable implications the exclusion of the provisions of the CRPC empowering the tender of pardon. And it was also held by the court because here was a special court which was established under the 1992 statute. There were sections 6 and 7 of that 92 statutes which conferred very, very wide powers, and that based on section 6 to 8, the court goes on to hold that it was a court of original criminal jurisdiction having all the powers of a court under the CRPC, which included sections 306 to 308. Now, these are the two decisions which has become the hot topic today. So I have laid the skeletal facts before this August assembly. And in fact, there is a stakeholder who is watching this matter. In fact, Advocate Sangeeta Lakshmana, who is a close friend of mine, she had the occasion to pose a similar question before a court, which the trial, of course, the trial has not been scheduled. Anyway, it's under consideration. Now, today we have great judges who are going to have their takes on these two judgments. And I would just say, let the ball roll. Thank you so much.
Thank you. Thank you, Prem. May I request Justice Prakash sir to start off the discussion, please.
Yes, Shyam. Thank you, Shyam, for calling me and telling me that it's at 4:30. Otherwise, I would really have missed it out. I'm extremely sorry. Very, very sweet of you to call me. Brother Ram Kumar, and I find the other learned judges there. Everyone, good evening to you all. Well, I heard with rapt attention what what is his name?
Premraj.
What Premraj said. Actually speaking, I am also in the dark. I'm really in the dark because I want some enlightenment from this Ram Kumar on this point from the other guests. But I believe I find Prem Kumar's thing to be very convincing. So I am also holding Prem Kumar's view from the Harshad Mehta's case, and I really feel that when the see today, lot of special courts have come. You see, the prevention of corruption, of course, PC Act special court was already there. Criminal Amendment Act was there. No, let's not go into that. We have SCHE special court, POXO special court. Every new law, the special courts have come, and we uniformly find that slowly this committal business is getting diluted, and original cognizance business is coming into stay. Criminal justice system. I'm sure we remember that in the 1898 court, committal used to be a big mini trial by itself. It was a mini trial by itself. So 1973 court gave away that mini trial business, and it started out committing the case. Now these new legislations are completely taking away committal and making all these special courts into original jurisdictional courts. And that's what Premraj was referring to. And as Premraj was saying, why should we deny these courts of original jurisdiction the power to grant pardon and instead make them run from pillar to post, go here, go there, get a pardon and come here, then put the magistrate in the witness box? All sorts of things should it be there or not is something which I feel that expediency and practical approach, very pragmatic, I would concur with Premraj's interpretation of that. I mean, not interpretation. This Sabharwal judgment is so clear; it doesn't require any great interpretation by anyone. And there is really no necessity to look out for a procedure in the code in the absence of a bar in the special acts for the special courts to grant tender of. After all, at the end of the day, the tender of pardon is given during investigation or it's given during trial. The person would be subjected to cross-examination by the defense, and whether his testimony is worthy of acceptance or not is yet another thing which ultimately the trial judge in his wisdom, in most of these special courts, I find the trial judges are of the rank of sessions judges, and so in their wisdom would know whether it's worthy of acceptance or not. That's it. So beyond that, I feel that to stretch the law would be doing violence to the thing. So this is my view in short, Mr. Premraj, as well, Mr. Shyam. I hope I was heard. I mean, is my
yes, very much.
I'm sorry. I mean, because there's no reaction. I thought.
No. We were silently hearing you patiently.
Yes.
To reduce the disturbances, we are muting others other than the speaker. That is why there is no.
You are not audible.
Shyam, you are not audible.
Am I now?
Yes.
Yeah, you are now.
Sir, Prakash sir, we are muting others during the presentation of one person so that there will be least disturbance. That's why, sir. Now, may I request Basant sir? Sir.
See, as some of you very humbly said, I must also say that I would like to be a listener here rather than to propound any final ideas on this. But I want a very fundamental question to ask. I'm just expressing my doubt so that we'll throw it open for discussion. Harshad Mehta says the court is a court of original criminal jurisdiction. Does every court of original criminal jurisdiction have power to tender pardon under 306 and 307 is a question. 306 at least is a question which we have to consider. Yes, it may be a court of original criminal jurisdiction. Does every court of original criminal jurisdiction have jurisdiction, competence, power to grant pardon? So that I think is a very fundamental question where Harshad Mehta appears to have it argued to say that it's a court of original criminal jurisdiction. Yes, very good. I have no quarrel with that. But does every court of original criminal jurisdiction have power to tender pardon under section 306? At the stage of investigation, at the stage of trial, there should be a problem. At the stage of investigation, does every criminal court, every court of original criminal jurisdiction have power to tender pardon, which you are perhaps reading down section 306(1). This is the way I look at it. I have a lot to disagree with Harshad, but be that as it may, both are by 3-judge benches. My question, fundamental question will be, why is 306 and 307 there? You have to follow 306 unless modified by the special act. Unless the special statute modifies, we are all bound by the, maybe PC Act, there is a distinction because there is 5.2, the present 5.2. I'm only referring to the present section. Section 5.2 is there, which gives the power of pardon to them also. But in an act like the Securities Act or maybe the POXO Act, where there is no power conceded to the special court to tender pardon in section 306, mere fact that it is a court of original criminal jurisdiction, will that confer on that court the power to tender pardon? I think that's a fundamental question which we may have to consider. Yes, I also say When it is once the trial is started, it may apply. But during the stage of investigation, what happens is the question which my limited reading of Harshad, it shows that it concludes that the court of original criminal jurisdiction. Very good. I don't think I can have a quarrel with that. But then, once you accept that, then the necessary corollary must be all criminal courts of original criminal jurisdiction have power to tender pardon during investigation. That I find is not the law under the Code of Criminal Procedure. And therefore, that aspect deserves to be considered. Now, one more fundamental flaw, if I may say so, in Harshad, as I find this, it says trial includes everything. I'm a little skeptical about it. Trial does not include all that the court can do. The trial, and after, what is that, Hardeep? Now, it is very well settled that the trial is only after the charge is framed. Maybe the preamble trial or the head-note trial, we need not take it very seriously. But even then, trial and investigation are two specifically different compartments. When 306(1) says that the CJM and the MM alone will have power to tender pardon while investigation is going on, how do we give that power to any other court of original criminal jurisdiction? These two things I find it's a little slippery in Harshad, and therefore that it is actually that, according to me, the basic fundamental question would be not whether these are courts of original criminal jurisdiction, but whether every court of original criminal jurisdiction does have the power to tender pardon other than, under Section 306. Well, 5.2 of the PC Act may call for a further discussion, be that as it may. But the mere fact that a court is a court of original criminal jurisdiction, in my humble view, cannot clothe it with any power to tender pardon, contrary to 306(1). That's the opening remark that I'll have to make. Please, that's all that I'll say now.
Thank you, Basant sir. Directly, may I go to Abraham Mathew sir?
Yes, I fully agree with the view expressed by Justice Basant sir. See, CRPC does not say that what are the powers of a court of original jurisdiction. I don't find any provision which says that a court of original jurisdiction has a certain powers. No. It is specifically stated which court or which magistrate or which sessions judge has these powers. We know that the procedure and powers are entirely different. So to that extent, I fully agree with Justice Basant sir. Now, in this Justice Sabharwal's decision in Harshad Mehta's case, there are fundamentally two flaws. One, the first one is this: merely because it is a court of original jurisdiction, a court does not get any power under Section 306 or 307. The second is that the fundamental difference between civil cases and criminal cases, or civil law and criminal cases, that only what is permitted can be done by a criminal court or even an investigating officer. On the other hand, in civil cases, what is not prohibited can be done. So in Sabharwal's case also, or this decision of Justice Sabharwal is specifically stated, unless it is specifically conferred, that power cannot be exercised. But at the end, he says that it should be deemed to have been conferred. Now, so with regard to these two facts, there are flaws so far as this Harshad Mehta's case is concerned. Now, the question here is, during investigation, whether this special court has the power. I would like to make a different approach, a new approach. You may call it an audacious one that may be necessary for some purposes. Okay, here when we read this section, subsection 5 or section 5, PC Act, similar provisions are there even in the Electricity Act. A special judge may, with a view to obtaining the evidence of any person supposed to have been directly or indirectly concerned in or privy to an offense, tender a pardon to such person on condition of his making a full and true disclosure of all circumstances within his knowledge relating to the offense and to every other person concerned, whether as principal or abettor, in the commission thereof, and any pardon so tendered shall, for the purposes of subsection 1 to 5 of section 308 CRPC, be deemed to have been tendered under section 307 of that code. See, if we divide this section into two, the first part confers power on the special judge. The first part confers power on the criminal judge, this special judge, to tender pardon. But the second part only says that once that pardon is granted, it shall be deemed to have been granted under section 308. This is all. What is all shall be deemed to have been tendered under section 307 of that code.
307.
First, the legislature perfectly knew that it was a court of original jurisdiction. The first part of subsection 2 does not say at what stage this pardon can be granted. It does not restrict the stage at which the pardon can be granted. It only says that pardon can be granted. What stage, it is not mentioned. So if that is true, that means at any stage. And the second part only says that once that is granted, whether it is at the investigation stage, inquiry stage, or trial stage, it shall be deemed to have been granted under section 307. For what purpose? For the purpose of section 308. So only for the purpose of section 308, it will be deemed to have been granted under section 307. Why such a fiction is created? If such a fiction is not created, we will have to comply with the provisions under subsection 4 and 5 of this CRPC. That is not applicable. They are not applicable. They are not applicable if a trial judge, sessions judge in ordinary cases, regular cases, suppose the sessions judge grants pardon. It is impossible to comply with the sections 306 and subsection 4 and subsection 5 of section 306. That is why the Orissa High Court in 1975 Criminal Law Journal, that is Criminal Law Journal 1937, which also followed by the Kerala High Court in 1996 Criminal Law Journal 1942, held that if that is impossible, it need not be complied with, because trial court itself is granting pardon, that power is given. So the sessions court, the legislature perfectly knew that it is impossible to comply with subsection 4. So it need not be complied with. Here the legislature knew that it's a court of original jurisdiction, and it is the only court in relation to which this investigation can be conducted. 156 always investigation, it is in relation to a court having jurisdiction. So all the investigation conducted in relation to this particular offense under this PC Act, the investigation is conducted in relation to the special court, original jurisdiction. So it means that when the legislature did not restrict the stage at which the pardon can be granted, it means that at any stage pardon can be granted. But once that is granted, it shall be deemed to have been granted under section 307 only for the purpose of section 308. Otherwise, the legislature would have certainly mentioned that not only for the purpose of section 308, but for all purposes. No, it is only for the purpose of section 308. So if we allow the latter part of section to control the first part of subsection 5 of section 2, then this is not a reasonable interpretation. That's why it mentioned earlier that it shall be divided into two, and the second part shall be, and the first part and the second part shall be considered separate. The second part shall be deemed to be a separate clause. Suppose it was inserted in a separate clause, what would have been the result? The same result. So the second part should not be allowed to control the first part, which says that special judge has the power to grant pardon, and it does not say at what stage. That means at any stage. This is the view I have, or this is the new approach I would like to make. This approach I have not seen anywhere made. So thank you very much.
Thank you very much, Abraham Mathew sir. This is Hariprasad sir. We would like to have your thoughts on this topic.
At the outset, I told you that I am only a seeker of knowledge. But then, after hearing this learned judges, I am of the view that I agree with Justice Basant that original jurisdiction is not the sole criterion for deciding whether there is a power to grant pardon or not. Because even in cases where there is original jurisdiction, you will not find from the provisions of CRPC, all the courts having original jurisdiction are clothed with the power to grant pardon. It is that is restricted in 306, whatever that is mentioned. Then Justice Abraham Mathew, by brother Justice Abraham Mathew pointed out that it has no nexus. It can't be annexed to the power of having inherent power to pardon. Because in Harshad Mehta's case, that special statute, and one important feature is that the court was presided over by 3 learned judges of the Bombay High Court, going by the constitution. Maybe that is, maybe of course, but still it is said that in the Justice Ramkumar's article, he has pointed out that the procedure under section 9(1), the special court shall follow the procedure prescribed by the CRPC for trial of warrant cases before a magistrate. That is the procedure prescribed for the trial of the offences under the Harshad Mehta's case. So virtually you are what you call annexing things to the CRPC, attaching things to CRPC. So can you have a separate consideration without going by the provisions of the CRPC? Can you evolve a new procedure? Maybe, of course, we are bound by the Supreme Court decision. We know that, but if you are allowed to think freely, I have my own what you call difference of opinion about the views taken therein. Then the other question, as I just pointed out, Mr. Abraham Mathew was pointing out that inherent power. Inherent power, of course, if you go to the history of section 482 CRPC, in fact, on the judicial side, I had occasion to consider that in the old code also there is a parallel provision akin to
561A.
561, correct, 561A. That was introduced in the year some 1939 or so, 29 or 39 in the 1897 Act, old code. So that, of course, at the time of incorporation of that provision regarding inherent power, what you call now covered by 482, the Privy Council observed in one decision that actually this is a recognition of power existing in court, as in the case of 151 CPC. But the difference is that in the case of a criminal court, unless it is specifically provided, they may not be able to exercise it. So you can't, as Brother Abraham Mathew pointed out, you can't simply say that, yes, I have inherent power, because then you will have to think about 362 and other provisions restricting the power of the court in certain matters. So my humble view is that inherent power can't be normally used by a criminal court. Maybe in a proceeding where this, of course, the powers under Article 142 or other provisions which are not available to high courts and other courts in the country. So whether the statute creating the special court confers a power or it connects the statute with the CRPC, probably that is the question. Viewing from that angle, I think this Harshad Mehta view is actually an enlarged scope, has been enlarged of granting pardon. That's my humble view. Of course, I'll be benefited by hearing the other view also possible.
Thank you, Justice Hariprasad, sir. Over to you, Justice Nagamuthu, sir. So you'll have to unmute.
No, I would like to hear the views of others so that I can make my responses sometime late. Please.
Sure, sir. But almost all the panelists, and I request anybody in the audience would like to have any comments, please do.
All right. So, Mr. Prem, please allow me.
No, can I say just one thing?
Sure, Basant, sir, please.
I think the situation would be entirely different if in the concerned act there is a provision similar to 5.2. Sorry.
Right, sir.
The position will be entirely different if in the relevant statute there is a provision like 5.2, in which event I would agree with Abraham Mathew.
Right.
But in a statute where there is no such provision, conferring on this criminal court of original criminal jurisdiction power to tender pardon, you have got to revert back to. 5.2 is a special provision. In the securities court, it is not there. In the POXO court, it is not there. In many other courts, it's not there. So our discussion primarily must be sans 5.2. Does a criminal court of original jurisdiction have the power to tender pardon at the stage of investigation? I would stress that.
Correct.
The other stages it has, I have no quarrel on that. But then at the stage of investigation, can anyone other than CJM and MM or any specially constituted. I thought it would have been much easier for the statute to say you'll have all the powers of a CJM, in which event he would have come under 306(1).
Exactly.
It would have been very simple. If that was the intention, it would have been the simplest method would have been to have all the powers of the Chief Judicial Magistrate. It can be done. Well, and powers, when you try to identify, you don't go by the person manning the court also. Just as he said, there's no inherent powers. Maybe the High Court judge, maybe the session judge, the powers of the court has to be spelled out from the instrument which creates them, the statutory instrument which creates them. And therefore, 5.2 should not confuse us now. 5.2 of the PC Act should not confuse us now. First, let us decide the question whether any court of original criminal jurisdiction have power to tender pardon at the stage of investigation under section 306(1). That, I think, is the crucial question which we are called upon to decide now. Because let me tell you, a magistrate, let's say a judicial magistrate of the first class, the case may be before him, the FIR may be not before him, but he has no power to tender pardon at all. Unless he is a CJM or an MM, he has no powers at all to tender pardon pending investigation. Words are very important. No 5.2 and pending investigation. I cannot find the process of reasoning by which you can say that a power which is not there in the CRPC can be given to the court in the absence of a provision like 5.2. This is what I wanted to say. I agree with Abraham Mathew. When there is a provision like 5.2 in any statute, that's a different situation altogether. Right now, we are considering what happens when there is no such provision, merely because it is a court of original criminal jurisdiction. Does it have the power to tender pardon pending investigation? That, I think, is the first question we'll have to answer. Thank you very much. Sorry for
I fully agree with Basant sir. That's why I mentioned that unless a power is conferred, there is no question of a criminal court exercising it. That's the main difference between civil court and a criminal court. Unless it is permitted, unless that power is given, cannot exercise it.
And Abraham Mathew, I think subject to correction in that that statute relating to that scam, there is no provision akin to 5.2.
No, there is. I checked. It is not.
They present to service section 306 and 307 because CRPC is made applicable.
Applicable. That is why I mentioned that I will not agree with the views expressed by this Harshad Mehta. The first thing is that unless it is specifically conferred, there is no question of the criminal court exercising any power. And CRPC, or for that matter, any other statute, does not mention the powers of an original court. Original court, the court having original jurisdiction, it is not mentioned anywhere. So, if that power is not given, it is not a procedure, it is a question of power. Unless that power is given, there is no question of a court exercising it. And the view taken by this Harshad Mehta that it should be implied. No. Unless it is specifically confirmed, because at the beginning itself, in that judgment itself, it is mentioned that unless it is specifically given, that power cannot be exercised.
All right,
So to that extent,
one thing can be seen, because in Kerala only probably we don't have second-class magistrates. In other states, probably second-class magistrates are still functioning, subject to correction. So they don't have power going by this.
Even first-class magistrate does not have, unless he's a CJM or an MM. First-class magistrate does not have powers today. Yes. Pending investigation. I stress pending investigation.
Even session judge.
Even session judge does
who is
not
the
have.
court of original jurisdiction.
Correct.
Yes.
Session court is a court of original jurisdiction. 193 says a session judge shall not take cognizance as a court of original jurisdiction unless the case is committed to him. Therefore, he is also a court of original jurisdiction.
Only once a committee is made, he gets that power.
CRPC doesn't say that a session judge shall not tender pardon during investigation because of section 306(1).
Correct.
That the enabling provision 306(1).
All right. Ramkumar sir said that. So the point that whether it is an original jurisdiction or not is not the sole criterion for deciding this.
Is irrelevant, I would say. It is irrelevant. I would go to that extent of saying, unless a power similar to 306(1) or 5.2 is conferred. One thing I have to enter a caveat. I completely agree with Justice Prakash that in these days of the era of special courts, not to give powers to the special court is taking the criminal justice system to a very, very bad situation. I also agree that that is why I said it could have been easily said powers of a special court will be that of the CJM, in which event he would have come in the 306(1) itself.
Correct.
Unfortunately, that is not there. And I should think that they advisedly did it. Excuse me for taking this time. I would think they advisedly did it because in most of the states, there used to be only one court. Securities court, for example, was only one court. If that jurisdiction is given to that court to tender pardon, normally the court which tendered pardon during investigation should not be clothed with the responsibility of adjudicating. Now, if that is so, what happens is, where will it go? Those questions would arise. And that is why perhaps advisedly they thought that the court which will be called upon to try should not be given this power to tender pardon pending investigation. They belong to two realms altogether. Though Harshad Mehta says trial means earlier pre-trial steps also. I have my reservations on that.
That is
therefore, I completely agree with Mr. Prakash when he said, what is this? This is making the whole process very cumbersome, unworkable, and therefore it ought to be there. The whole thing would have been very easily done by adding the power of the special court will be that of a CJM, in which event he would have walked into section 306(1) and would have been entitled to grant pardon, but he will have to try it himself. That problem will also be there.
Yes.
Right?
Yes.
I just wanted to make that point clear before we go to the next.
Correct, Basant. He could have been deemed to be a chief judicial magistrate.
Very
for
good.
The purpose of the act.
Easily that would have been done.
The question of power, the question of the nature of the power.
Yes, sir.
Most of the problem we face today is whether Supreme Court or High Court. See, we all of us, you were a judge and now I am a judge. The problem is, when such the legislative thing appears to be totally cut out of the reality, they in a hurry they legislate something and go away. Then it becomes our job to sustain such things by a convoluted interpretation of whatever it is. Now, Justice Basant, Justice Nagamuthu, Justice Ram Kumar, all of you all can really decry this and say that okay, this is not correct. But when we were sitting as judges, when this problem used to come before us, we'll have to find out, okay, if this accused is going out just because we are given interpretation that this special court does not have power to grant a pardon. That would weigh in the mind of, the problem, the thought process of a judge is totally different with the thought process of a lawyer. For the lawyer, they're gaining the case. For the judge, there's so many factors will apply. That is why, every time Supreme Court, I find, tries to bend the whole thing instead of saying, all right, nothing doing. This act does not have tender upon powers. Go to hell. You legislate better.
So Prakash, you make the confession to police also the admissible. We are paying.
Sir, not go to hell. Go to the CJM.
Police also the admissible.
It's not go to hell, sir. It is go to the CJM. Or if you are in a metropolitan city, go to the metropolitan magistrate. No, not having done that, to say that this must be condoned, this inadequacy of law, inadequacy in the procedure ought to be condoned because of the consequence, I think would go against the fundamentals of our criminal justice system.
Correct.
I do realize. No, I think there is immediate necessity to amend the law to say that to either bring in a provision like section 5.2 in all the similar statutes, or to say that they shall be deemed to be not a magistrate, but a magistrate empowered under 306(1), that is the CJM, or include the first class magistrate also in 306(1). There are many methods which appeals to them as a different question altogether. But to say that we have to resort to convoluted reasoning in order to justify an improper act done, I may respectfully not agree, because that is not the tenor of the criminal law in this country. That is the way I look at it, sir.
May I pose one question?
Nature of power of the criminal court was considered by the Supreme Court in 1958 itself. Then the Supreme Court has said that unless there is a specific provision, even a free copy of a judgment cannot be given to an accused. Even for that, there should be a specific provision. So, in the absence of a specific provision, no power can be exercised by any court, criminal court. That is the view taken by the Supreme Court in 1958.
So, may I pose one question? Sir, one question, please. Suppose the special court grants pardon, will it forfeit the right to try the case then?
No, that's not necessary, because even now the special court can grant pardon during trial.
Hariprasad, then the question will be, which special court are you talking about? If it is the 5.2 special court, no. If it is
No.
any other special court, the grant of pardon would be contrary to law, and then that order will have to be set aside.
That
You
is
may
right.
continue
Fine.
to hold the trial.
I'm not asking about 5-2 court. It's a different court. Let us go by this Harshad Mehta's decision. Then will it find it difficult to try the case?
Right, excuse me, I'm again saying, see, if a first-class magistrate who's not empowered under 3061 grants a pardon, what will
Yes.
happen? What will happen? That order will be set aside. He may have to proceed with the trial. See, I'm
Right.
talking about a simple judicial magistrate of the first
Okay.
class. He is a court of original criminal jurisdiction. He does not have powers under section 3061 to grant pardon when the investigation is going on.
Correct.
He takes it upon himself and grants pardon. Right? What will happen if you ask me? I will only say that order will have to be set aside and I stop
Right.
from there. Nothing more. Right? Okay.
Yes,
Sorry.
Nagamudha, sir.
Yes.
Sorry, Basant sir, please. You may
No,
complete.
I'm done. I said I'm sorry. Right?
Just
Yes, Nagamudha, sir.
knows that there is a supporter here. Yes.
So I thought when you put your hands up, sir, anyway, out you.
No, it's very interesting. So I'm raising a totally different issue now before you. Whether the High Court itself is a court of original criminal jurisdiction or not. My question is that. Please report to Section 6. Section 6 CRPC speaks about the classes of criminal courts, which includes the High Court also. So High Court itself is a criminal court for the purpose of CRPC as per Section 6. Now, if you go to Section 26, the High Court has got power to try also, right?
Yes.
Whether the High Court has got original jurisdiction. Now, you say that Sessions Court doesn't have a court, no, it's not a court of original jurisdiction. That is what we are saying. It gets the status of a court of original jurisdiction the moment the case is committed to that court. Until then, that court has got no original jurisdiction, right?
Is that correct? I don't think so.
Yes, it
It
starts
shall not take cognizance as a court of original jurisdiction.
original
That's what the
jurisdiction. Yes,
Section says.
as a court of original
Yes.
jurisdiction.
But it shall not take cognizance as a court of original jurisdiction unless the case is committed to it.
Committed. So therefore, it has got original jurisdiction. High Court has got original jurisdiction. As it was rightly pointed out by Hon'ble Justice Basant, if every criminal court having original jurisdiction is empowered, as stated in Harshad Mehta, High Court can grant. Every Sessions Court can grant, even at the stage of investigation. Because section under 306, if you say that it is a court of original jurisdiction, then that court can also grant pardon. But nothing is said so explicitly or impliedly in section 306 about the Sessions Court, right? Sessions Court comes only under section 307 at the time of trial. Here also there is some difficulty. This was also highlighted the other day. So as a court, this section 307 does not speak about a court of session at all. Please kindly see that also. It says that at any time after commitment of a case, but before judgment is passed, the court to which the commitment is made, that court alone has been given power, which means there can be only one court to which case can be committed. That is a court of session. Whether additional session judge exercise the original jurisdiction, never. Because under section 194 CRPC, he can try only those cases which are made over. He cannot give, he doesn't have original jurisdiction. You take the revisional jurisdiction, unless the case is made out to him, he cannot do. You take appeal jurisdiction, revisional jurisdiction, any jurisdiction for that matter, additional session judge or assistant session judges have got no original jurisdiction at all. So if the case is tried by him, let us assume at the time of trial, an additional session judge tries, can he give pardon now? If it is construed as court of original jurisdiction, you say that as per Harshad Mehta, all right, it is an omnibus provision, you can give pardon. But you look at section 307, it restricts the power only to the court of session. If the court is case committed, it could have been well said like this. How at any time after the commitment of a case is made, but before judgment is passed, the court which tries, that should have been the proper language. If that was the intention of the legislature to confer power upon the additional court as well. Why should
But
they
once it is,
specifically,
sir,
Court to
Once
the
it is
committed.
once it is made over,
Yeah.
that court gets all the powers of the sessions court.
No, the
Yes.
question is, question is.
Only with regard to this administrative work, he does not have in right. But
But
once
how
it is made over to him, he
Yeah.
gets all the powers. That is what the Supreme Court has said.
But
Yeah,
how
they
to
will
explain
just like any
307?
other sessions court.
Can the
307.
case be committed
Court
to
to
the
which
additional
commitment is made.
whether case can be
No.
committed directly to the additional
Additional session judges are also appointed to the sessions court.
No,
They
actually,
are also
see-
judges of the sessions court.
No, they work within, they function
all
within the
right.
court of session. No doubt about that. They function within the court of session. But powers are different. They cannot
Only
take cognizance.
The powers are different,
They
only
exercise-
not judicial
Can
powers.
they exercise
Judicial
the power
powers
under
are the same. Judicial powers are the same. Only this administrative work, they are different.
I fully agree with you that the judicial, most of the judicial powers are common. But section 307 specifically says and particularize a court, the court to which the case is committed. It doesn't say
Can
that
I?
the court which it tried.
There is only one court. There is only one court in a sessions division. That is the sessions judge.
Yes.
They are all appointed to the sessions court. They are all judges of the session court.
Can you say
So that is the
then
court. They are also judges of the same court which the commitment is made.
could you please, could you then say that they can also take cognizance on the case? Can the case be committed to the additional court directly?
No, once
No,
made
no.
over. Once made over.
Once all made over, that's all.
Once made over.
What is the power?
Made over after cognizance.
Power given is only to try, nothing more. Please kindly see the provision under
Yes.
190.
Then 307 is a power can be exercised during trial.
What are all the powers which can be exercised as a trial court? It can certainly exercise, no doubt about that. All the powers of a trial court, this court can exercise. But section 307 does not say that it's a trial court. It specifically says that the court to which it is committed. So I am
Nagamuthu,
raising two issues now. Please, for your
His court
consent,
also
number
is a court. His court is the same court, not a different court.
No, so just 1 minute, if I may clarify. The committal referred to in section 307 is not the committal under section 209 alone. It includes the committal under section 306(5) also. Please see that.
Yes.
Yes.
A case triable by the CJM's court also will have to be committed. May not be under section 209 because it's a sessions offense. Because the CJM has tendered pardon, then also it has to be committed. So the language of section 307 covers not only the cases committed under 209, also the cases committed under 306.
Yes.
If that is there, we need not enter into this controversy about the distinction between the powers.
No, you please, can you look at section 323? Section
They are also same thing.
Under 323 also, any case, though not triable exclusively, the magistrate can commit. There is another commitment. It's not under 209. So commitment means to give jurisdiction to the court of session to exercise its original jurisdiction.
305, 305, 306, 5A also you may see.
There is one
5A1. 5A1.
under 209 there
A1.
can be commitment. Under
Yeah.
306 also, 306 5 also there is commitment.
5A1.
Yes. Under 209 there is commitment. Under 306 5 there is commitment. Under 323 also there is commitment.
Correct, sir. Correct, sir.
There are three
Absolutely.
commitments. So
Right.
it says that the court of session shall exercise the court of original jurisdiction to take cognizance only if the case is committed either under 209 or under 306 or under section 323. Until then the court has got no jurisdiction. So my point is, they could have very well said that the court, the sessions court or additional session court, whichever court, the court which after the case is committed to the court of session, the court which it tries can give pardon. That is not the language used. They restrict it. They say only to the court to which the case is committed. Additional court is not a court to which the case is committed. Case is committed to the session. If we are going to give a liberal interpretation to say that the additional session court and session court are one and the same because they work within the, they function within the section, the division, then we can very well say that case can be committed to him. He can exercise the power under 438. He can exercise the power of transfer. He can exercise the power of revision. Everything can be given to him. No, if you look at revisional power also, additional section power is so much restricted. Unless the case is made out to him, he cannot exercise the revisional jurisdiction also. Of course, it is a suo motu jurisdiction. Can he do that? He cannot. So therefore, 2 points I want to raise. High Court can try an offence. If under 306, High Court cannot give pardon. Suppose the case is tried by the High Court. Under 306, strictly speaking, plainly speaking, under 306, the High Court cannot give pardon because the case is trial stage. Now, if you come to section 307, the High Court, if the case is committed to the High Court, then only High Court can give pardon. Otherwise, High Court cannot give. Suppose the High Court withdraws a case and tries it. Can the court give pardon? So these are all the areas which are so nebulous, as it was rightly suggested by Hon'ble Justice Basant. These provisions require relook and necessary amendments are to be made. This is my, that's all I want to say.
Can I come in for one
I
minute,
fully
please?
disagree with the Harshad Mehta. No doubt about that.
Okay,
I
sir.
don't agree with that view. I agree with the view expressed by Hon'ble Justice Basant and Justice Abraham Mathew and Justice Hariprasad.
Sir, may I come in with just 1 minute? Nagamuthu, sir, 1 minute, please.
Please.
Actually, see, I would like to support Abraham Matthew's view for the reason that because there is only one session division where there may be so many judges functioning because of the business has exceeded a particular limit. One person cannot handle it. So in that situation, as you rightly said, the power is only after making over the case, the additional session judge gets power to dispose of a case. But
Yes.
the commitment is to the Sessions Court, wherein this man is also part of the Sessions Court.
No,
So
it's not part. It's not part.
Sir, 1 minute, sir.
Just like the High Court, there is only one High Court and several judges are there. All are exercising the powers of the High Court.
Right. See, of course, his power, 1 minute, sir, his power to dispose of the case arises out of this making over. That is an administrative act. It has nothing to do with judicial function.
Which one?
Making over of the case. It's not a judicial function because odd or even, there is a system followed in many cases in our place.
If you are
No, I'm not talking about commitment. Making over.
Commitment is a judicial order or not?
Commitment, of course, no doubt. There cannot be. It's a judicial order.
This order should also be treated only as a judicial.
No, sir. If you read this section in this way.
Hariprasad, if you will give me one. Commitment is to the court and not to the principal session judge.
Correct.
Commitment is to the court of
Sessions
session,
Court.
and all are equal portions of the same criminal, the sessions court.
Exactly.
That would answer, of course, subject to what Mr. Justice Nagamuthu says. No, we can think about that, but for the moment, I would think we are deviating from the main issue now. Our question is not that. As somebody rightly pointed out, even the High Court cannot exercise powers under Section 306(1) to grant pending investigation. The High Court, even though a court of original criminal jurisdiction, cannot grant the pardon.
No, my 2 points. Whether High Court has got original jurisdiction, number one.
No, sir, because that is spelled out from Section 6. Now, who read that? Section 6, somebody read. And it says, in addition to the High Court and the...
Correct. It opens with that.
Classes of
that is why they said that.
Classes of courts.
Classes of criminal courts.
Criminal courts.
No, I think we need not enter into that controversy now. High Court is a court of original criminal jurisdiction, but in spite of that, it cannot enter pardon under 306(1) pending investigation. That is what.
All right, Justice Nagamuthu.
A matter, and in the course of the trial, the court wants to grant pardon. It may be open to it to grant pardon, but otherwise, the High Court cannot grant pardon under Section 306(1) pending investigation in any case, including one which it may eventually call upon himself. Pending investigation, it cannot be done, right?
I think Brother Justice Nagamuthu and Justice Prakash may be knowing because this is Madras High Court itself was handling original jurisdiction, sessions jurisdiction at one point of time.
Yes, it was handling, but what happened was we abolished it in 1955.
Correct.
What we did was we were as the court of original jurisdiction. Madras presidency, Madras city was sessions court. Yes. Madras city sessions court was High Court. High Court was the Madras city sessions court. So we were having the thing with the jury trial. Right. But what we did with the 1888 court had all the provisions to support the original jurisdiction of the Madras High Court for a jury trial, as well as taking committal was there. Even then there was committal. From the Chief Metropolitan Magistrate, I remember that this famous
Nanavati.
Nanavati was Bombay, no. Yes, Madras is that Tyagaraja Bhagodar. There is Lakshmi Kantan murder case. Tyagaraja Bhagavathar is that film star. Lakshmi Kantan murder case. Well, committal was there, and trial was conducted on the original jurisdiction of the Madras High Court, which was under the charter as well under the 1898 Court. But what we did was 1955, we brought about an amendment removing the original jurisdiction, giving it to the Madras Sessions Court. We transferred it to the Madras Sessions Court. Okay. Since then, we neither the same 1898 Court started applying in 1955 till 1973, when the new court came and took over the whole thing. Yes. That is what is the broad history. But as Justice Nagarpattu says, it's a moot question because CRPC also recognizes the original jurisdiction of the High Court here as a criminal court, but it's a moot question.
No, see, if the High Court feels that one case has to be tried by the High Court, it can withdraw and try it because that is the power
that is there.
Case be committed to the court of High Court, sir. Whether a case can be committed to the High Court?
It can't be because
this scheme is there is no provision. Right. Point number one. Point number two. If it is to be construed as a court of original jurisdiction, that court should have the power to take cognizance. Whether is it a magistrate court to take cognizance? No.
If it can try a offense.
How the case will go to that court first? How it will reach the High Court?
I don't know.
But sir, but in the Hardeep Singh, they say two cognizance. Cognizance twice. I remember we were discussing.
Right. Cognizance at different stages.
Two cognizance. I think you were also not very happy.
One by the magistrate and one by the session judge.
Yes, Hardeep Singh is the 5-judge bench. I think.
Yes. Dr. Chauhan.
I think that there is anything wrong with it because
Dr. Chauhan.
Police also take cognizance when they register a case. Cognizance will only becoming aware of, nothing else.
Aware of.
In that sense.
Correct. Yes, aware of. You're right.
Dharampal, this Altamas Kabir, in clear terms, rightly or wrongly says like this. In a case, cognizance can be taken
only once.
Dharampal, yes.
That means
that is how we understood the law for a long time, right? That is how we understood the law for a long time. But the nuances of the definition of cognizance gives room for the other interpretation also.
Yes.
Right? See,
what is cognizance? There is no magic in that word.
Yeah,
only means becoming aware of.
Right. Many times it has been said there is no magic. Now, when the court applies its mind with an intention of proceeding further, taking action, that is cognizance by definition. And therefore, you can have two cognizance also. Perhaps you can't raise an objection to that. The Constitutional Bench having said that.
Therefore, if the whether now question is, if the High Court is a court of original jurisdiction as per Harshad Mehta, High Court can give pardon. My question is whether it is High Court is a court of original jurisdiction. If it is a court of original jurisdiction, the court can take cognizance.
The Harshad Mehta, the High Court was not taking cognizance as High Court. It was taking cognizance as a special court. That was the whole problem. See, it was not taking cognizance as a High Court. Maybe judges are the judges of the High Court, but they are nonetheless courts, special courts under the Act. They do not have the High Court's powers.
Yeah, please, I understand that. Right. I understand that. There is a distinction. Right. As a special court, they say it is a court of original jurisdiction, and therefore that court can give pardon. That's what they say.
Yes.
Now, my question is, High Court is different. Whether High Court is a court of original jurisdiction to give pardon. Now, High Court has got power to try. I am yet to find an answer as to how a case will reach the session court unless it is withdrawn by the High Court. Let us assume that High Court itself withdraws a trial, a case to that court.
High Court can withdraw. I think some provision CRPC by which it is said High Court can withdraw to itself any case pending before any court. And therefore, it can withdraw and proceed with the trial also.
Yes, that is the only way. That is the only way by which a case can reach the High Court.
Right, sir.
Right. 402. Section 402 CRPC.
402. Right.
That's what withdrawal.
Yes.
So while doing so, whether that court becomes a court of original jurisdiction, so to grant pardon, that is also a moot question.
According to me, not pending investigation. Yes, pending investigation only under section 306(1), in which event no court of original criminal jurisdiction stands a provision like 5(2) or 306(1) can grant pardon at any rate. Be it the High Court, it is the second class magistrate court, if it's a criminal court, it cannot. The mere fact that it is a court of original criminal jurisdiction does not clothe it with powers to grant pardon. That is the net view that I would like to canvass.
Yes, yes, we fully endorse the view. Only to add support to this view, we are saying all these things. Whether High Court can grant pardon at any stage, during investigation or during trial, cannot. The court cannot do.
No,
so it is so crystal clear.
During trial, it must be the jurisdiction of either the magistrate or the CJM or the Sessions Court that the High Court is exercising. When it withdraws to itself, it has all the powers of the court from which it is withdrawn. And by that reasoning, maybe it can grant a pardon pending the trial. I'm only hypothetically saying.
Yes, because there is only warrant trial and summons trial.
Yes. Sessions trial, warrant trial, summons trial, summary trial.
Session trial is warrant trial only.
Steps into the tools of the trial court.
Sessions trial separate. It's not warrant trial. Sessions trial is separate.
It's a modified warrant trial.
Form of warrant trial.
That way, warrant trial is a modified summary trial or a sessions trial. I mean, what is that? Summons trial.
Summons trial.
Or a summary trial. We are not on that. The code recognizes 4 different procedures of trial: summary trial, summons trial, warrant trial, and sessions trial. When the High Court withdraws a case pending before any of these courts and withdraws to itself, it proceeds to exercise the powers of that court, which means under section 306(1), a court trying the offense can grant pardon also. High Court may also be able to do that. But pending investigation, I have my doubts. Following the CRPC, High Court also cannot grant a pardon pending investigation under section 306(1). Yes, that's all.
No, see that withdrawal, and my friend was referring to section 402.
That is revision, withdrawal of revision.
No. So there is some other provision by which says transfer provision. Look at the transfer provision. Yeah.
406.
Withdrawn transfer revision, or maybe 406.
And it have all the powers. I'll show you that.
407.
Revision. 407. What about 407?
407.
Yes.
6.
Case and appeals. Transfer
407.
Yes, 407. 402 is only particularly revision, actually. Yes.
Yes.
You say 407?
Yes. Please look into
that any particular case or appeal be transferred to and tried before itself.
Fair or impartial trial.
407 clause 4. It may order 4. Entry number 4.
Before itself, you are right.
Particular case or appeal be transferred to and tried before itself.
No, is there a specific provision which says when such withdrawal takes place, the High Court's power will be that of that court?
No. That's not fair. But it's subsidiary of that court only.
I think that is not required, because once you exercise the power of a court.
I was just trying to find out if it is there. Let us close the discussion on this. Isn't it?
Right.
To my knowledge, there is no
407 C4.
407 C4.
C4.
Any particular case or appeal transferred and tried by before itself. Correct.
C4, right? C4 is what they refer to.
Yes, correct. Whenever it is made apparent that a fair and impartial inquiry.
Subsection 8 of 407.
Subsection 8 is there.
8
is there.
High Court orders
when the High Court orders under subsection 1 that a case.
Right.
Such trial. Correct. There is 8.
Shall observe in such trial the same procedure which the court should have observed if the case had not been so transferred.
Correct. So High Court also will be bound by 306(1) my short point.
Summons or warrant or whatever it be.
Whatever it is, that will follow. And if that court did not have powers to grant pardon, High Court will not have the power to grant pardon. If it has, it has. If it has not, it has not.
High Court does not have any independent power to try. Independent, rather not independent.
Why should this much of complication? It can be made very simple by making necessary amendment.
No. The point is, see, as Justice Prakash has rightly said, the advice to amend is a different thing. Judges are bound to decide it the way it is. They can't say amend. And that is why my law, the Justice Prakash points out that, see, sometimes we have to resort to convoluted reasoning to give a meaning for the present provision. You can't throw your hands up. No, but then I would say, but that cannot be to spell out a power of pardon when none exists. That is my only point.
Yes. No, there are only political speeches during a debate. That is the problem here now. Only political speeches are made during debate in parliament.
No, we should not also be that. That's what I'm saying. That is what Justice Prakash pointed out. To say that it can be amended is one very easy thing to say. But then, as Justice Prakash rightly said, their lordships are posed with the problem how to make law effective the way it is. Not to say that it can be amended. That's a very easy way of saying that.
So in such an event, there is one problem going on in our state, and our rules committee of the Madras High Court, I do not want to mention the name of the honorable judge who is heading the committee, because it may embrace him subsequently.
Don't say, sir, but tell me the point.
Point is very simple. See, on the orders of the Supreme Court, there are special courts constituted for trying the MPs and MLAs case. What are their jurisdictions?
Brother Nagamudhu sir, please, I will go out.
No, please.
Then,
let us not drag controversial matters into this.
We need not.
I have already given my report.
No,
I have already given my report to the
you are also there, sir. Sorry, we should not discuss that.
No.
Let's leave it.
Let us stop it there. No.
Yeah.
Sir, 1 minute, sir. Justice Prakash and Justice Nagamudhu, they are former judges of the Madras High Court. I mean, Justice Nagamudhu, of course, yes. Prakash is present.
He is not former, he is present.
No. See, I just wanted to tell you one joke, one anecdote. Because when this Madras High Court had original jurisdiction and sessions trial happening, my senior used to say that one Mr. Ithiraj, a eminent criminal lawyer, was defending almost all celebrated cases, and it started ending in acquittal. Lot of cases went on acquittal, and finally it has become a disgrace to the investigating agency and the prosecutor. And ultimately, he was made the crown prosecutor. There is a story like that.
Yes. It's apocryphal. It's apocryphal. Very nice. Thank you, sir. Shall I have your permission?
Sir, we'll do one thing. For the time being, if Ramkumar sir want to add something onto the discussion that has transpired, especially on the notes he has prepared.
Yes, sir.
Not to complete. My doubt on Harshad Mehta is that, of course, I am prepared to concede that since CRPC is made applicable to the special court in Harshad Mehta, probably they are justified in invoking section 306 and 307. Since CRP 306 and 307 are also part of CRPC. That way I am prepared to concede that. But then when the special court is established only for trial, and trial we have a definite meaning as explained by Constitution Bench of the Supreme Court, the Kerala of the Supreme Court. The trial starts only with the framing of charge and thereafter by the court. Then how can there be a power exercised under section 306 during the stage of investigation? That is one doubt which then in the case of PC Act, how do you justify section 306 5A2? How do you justify section 306 5A2 after the pardon is tendered during the stage of investigation by the Chief Judicial Magistrate or by the Metropolitan Magistrate? He has to be examined by the magistrate taking cognizance of the offence. In fact, PC Act does not contemplate any committal. In spite of that, CRPC, notwithstanding 52, right from 1952 Criminal Law Amendment Act, the special court under the PC Act can take cognizance without a committal. In spite of that, the legislature did not, the framers of the court did not think it necessary to amend CRPC, notwithstanding the enactment of 1988 Act, PC Act. Therefore, now how to explain section 5A2, where a person has accepted a tender of pardon made under subsection 1 and has been examined under subsection 4, the magistrate taking cognizance of the offence shall, without making any further inquiry in the case, commit it for trial to to a court of special judge appointed under the Criminal Law Amendment Act. That is why Justice Sikri rightly observed that there are two routes. One, the committal route, and the other, direct cognizance route, where during the stage of investigation, there is a request for tendering pardon to an accomplice, then it can be done only by the metropolitan or the CJM or the metropolitan magistrate. In that case, the charge sheet has to be filed before the magistrate competent to commit the case. Whereas if no pardon has been tendered during the stage of investigation, then the charge sheet has to be filed before the special court. Special court can take cognizance, and if necessary, can tender pardon, which will be deemed to be under section 307 CRPC. That is how we can reconcile these provisions.
No, Ramkumar, you can reconcile it the way Abraham Mathew said also.
Yes.
See, once you are granting a pardon under 5.2,
yes,
the provisions of 306 and 307 have no application. It will be deemed to be one granted and for the purpose of 308 only, which means supposing the special judge grants pardon. Now, if 308 is not there, there will be no teeth for that, and therefore it shall be deemed to be one for the purpose of 308 alone.
But then Criminal Law Amendment Act has identical provision, section 8 has 5.2.
Maybe
8.2.
Maybe so. That is why he said we'll have to adopt that interpretation now, to say that when the pardon is granted under 5.2, you do not go back to 306 or 307, but that pardon, if not followed, not complied with, man must be prosecuted. For that purpose, 308 alone, the presumption applies. I appreciate that argument.
Yes. Can 5.2 pardon be granted during the stage of investigation?
Any stage, because as Abraham Mathew rightly pointed out, it does not specify the point at which it can be granted.
That is precisely what Pascal Fernandez said. While section 306(1) says any stage, CJM or MM can grant pardon at any stage, including investigation. Section 5.2 or 8.2 does not say any stage. Therefore, the special court comes into picture only from the date of cognizance.
When the stage is not specified, it means any stage. That's the only way to look at it now. When the stage is not specified,
can it be inferred? Can it be inferred?
Obviously.
Read the section 56 or 56, 156. So investigation is always in relation to a court which has jurisdiction. So there is an agency, there is a court. These are the only two agencies involved in it.
I think 5.2 can help you out of the situation, according to me. But what about the enactments where there is no 5.2 similar provision? Like as Justice Prakash said, POXO, for example, the
NIA Act.
N number of cases there where it is not there. If a provision similar to 5.2 is there, I would have interpreted it very happily to say that 5.2 does not specify the stage, as Abraham Mathew pointed out, and therefore it must cover every stage, both the stages covered under section 306(1), that is before investigation, after cognizance. Both are covered. And therefore, I wouldn't find that a great problem. Though, of course, Pascal takes a different view. I should note that too.
But what about the court of session? Session court, CRPC doesn't say session court shall not enter pardon during investigation. By interpreting 306(1) that we say, enabling provision 306(1), that if it is a offense triable by a court of session and pardon has to be tendered during investigation, you go to CJM.
Because of the specific provision controlling that power on another judicial officer, it is excluded.
306 exclude 307.
307 exactly. Covers that. 307 covers that, isn't it?
Correct.
Once it is committed, the court has powers under 307.
Not after committal. Before committal, during investigation. CRPC doesn't say session judge shall not tender pardon during investigation. By interpreting 306(1), we say that during investigation, CJM and MM, Metropolitan Magistrate alone have got the power.
Sir, that is because, sir, at the time of investigation, nobody will know whether this is going to be a sessions case or it's going to be a ministerial case, sir. At that time, it would be very hazy. An ordinary 326 case may turn out to be a 302 at a later point or something like that. As you are a session judge yourself, you know. So that is why 306 excludes 307. There is one investigation means it is 306. As Justice Basant points out, sum and substance is that 306 investigation, 307 trial. So when the specific provision, as Abraham Mathew J says, then why should we toy for 307 into 306?
306 also speaks of trial.
But 306 only magistrate.
No, 306 also speaks of trial by a magistrate.
Magistrate.
Investigation at the time of investigation.
No, even otherwise. 306 pardon
yes.
only by magistrate.
Correct.
Magistrate, and during investigation only CJM, not magistrate.
CJM, not
Yes.
CJM alone.
CJM alone.
CJM or MM?
Exclusive for MM.
MM and
Exclusive
CJM.
for this CJM or MM.
Yes, sir. Yes, sir.
First class magistrate can't do it only at the time of inquiry or trial. He can
Right.
Trial.
Right. That's the answer. That's the answer according to me.
Thank you, sir. Shall I? By some guests have come.
Thank you, sir.
Shall I?
Justice Prakash. Thank you.
Thank you,
Nice
brother.
meeting
Thank
you.
you.
Nice seeing you, Mr. Prakash. Justice
Pleasure.
Prakash,
Pleasure.
thank you very
Pleasure.
much.
Pleasure,
Thanks
sir.
a lot.
But I'll keep troubling Ram Kumar ji again.
you are entitled to at any time, any day.
I have already given you some questions to answer. Thank you, sir.
Thank you very much. So, Nagmuthu sir, anything to be added on today's
We
deliberations?
fully agree. Today, I think after a long time, today is the day when we all of us concur on certain issues.
We can agree to disagree also, no problem.
That is the usual practice, but unusually today everybody agrees.
Beauty of laws, the scope to disagree, isn't it?
Right to dissent.
So, may I, while
You
we
may
come to-
ask, there are several participants, you may have their views also. There are several
definitely, sir.
But
Questions
one
are
thing,
made by
I forgot to
Ambika
mention one
Padi.
thing.
I have requested to unmute,
Shyam,
but
I forgot to mention one thing. Even in Kerala and Tamil Nadu, even now,
Hmm.
PC Act offences during investigation, CJM is tendering pardon, not the special court.
Right,
And
right.
like,
As
and
the
what,
ought
and
to, I would
NIA,
add.
and what about NIA court in Kerala? During investigation, it is the CJM granting pardon, not NIA court.
NIA Act doesn't speak anything about that power actually. There is no mention in
No, but then CRPC is made
Correct.
applicable.
CRPC
It
is
deemed
made
to be a
applicable.
court of
Correct,
session.
correct.
So adopting the reasoning of Justice K.T. Thomas in that but 2000 Supreme Court, if the state government may specify a court of session to be a special court, means it is a court of session.
That is a SCST case. No.
SCST.
case.
Yes.
Section 14 pre-amended.
Because
Unless it is a special
Kerala
court
full bench
constituted.
was overruled in that because
Overruled.
Kerala full bench said
Yes.
that only on cognizance SCST court can take cognizance.
Because it is a
Sorry,
special court.
it was a special court. That is what the Kerala
Yes.
full bench said.
Yes, no committal necessary.
Supreme Court said committal is required in that.
Yes. Because essentially it is a court of session.
Correct.
And if you examine POCSO Act also says the state government may specify a court of session to be a special. So basically it is a court of session. So all the power, all the provisions are applicable to a session court. During investigation, after committal, all these will apply. In NIA courts, during investigation, the CJM is granting pardon. In Kerala, I don't know about Tamil Nadu.
No, in the Supreme Court has held that is a concurrent power. It's concurrent power. They have concurrent power.
That is Bangaru Lakshman.
Bangaru Lakshman is not that.
Yes, Mishra.
This is
PC
KSR,
Mishra.
KSR.
PC
I don't
Mishra.
remember again. That is in
PC Mishra.
2014. Year
Mishra,
2014, maybe.
That
Year
is-
2014, Supreme Court 1921, I think.
That is PC Mishra. How can it be concurrent during
That is what the
investigation?
Supreme Court has said.
If during investigation CJM alone can grant the pardon,
Yes.
it cannot be concurrent.
That is based on this Harshad Mehta, I think.
Ah,
Harshad Mehta was adopted and said that even during that stage, this special court has jurisdiction. Then
Yes.
it said that CJM also has got under section 306.
That is Gangula Ashok, I think.
Gangula.
Gangula Ashok. Gangula Ashok.
Is that SCST case?
Yes, SCST case.
Gangula Ashok SCST, correct.
Yes. Prior to the amendment,
Amendment.
section 14.
Right, right.
Now that court can take cognizance without a committee.
Yes, that is after amendment.
And PC Act says without the accused being committed to the court. Not,
Not
without
case
the
being
case.
committed.
Not case. Without the accused being committed to the special court.
No, many words are loosely, many provisions are loosely worded. after we became
what is the need for the presence of the accused when the court is taking cognizance?
See, the number of advocates, especially practicing advocates in this parliament, has come down. That's the problem.
that is the fodder for lawyers, actually.
Right.
So, sir, if no further comments or inputs from the participants,
What about the viewers?
Yeah, I mean, Ambikapati has
nobody
posted, and I requested to unmute, enabled also, but
what about our
very
special judges?
One question has come up. One question has come up from Sangeeta Lakshmana. That is, an application was filed at the investigation stage. Can that application be considered after the court has taken cognizance of the offence?
Which court? Which court?
NIA court.
NIA court.
Yes, a court of session.
I have unmuted Sangeeta, please.
All the powers of session court. During investigation, what is the question?
Application for tender of pardon. Sangeeta?
Please carry on. Prem.
Yes, just come.
No, the question I wanted to put across was whether an application was filed by the investigating agency during the investigation stage. Can it be considered by
Before
the
whom?
NIA?
Before whom?
Before the NIA court, special court, NIA special court.
Before the special court, during investigation.
Yes, during investigation. Can this application be considered after the court has taken cognizance of the cognizance on the offences against a certain other accused?
Actually, it should have been forwarded to the CJM if it was during investigation that the application was filed, as was done in PC Misra. PC Misra, the application was filed before the special court during investigation. Special court forwarded the application to CJM.
CJM authorized another magistrate.
Yes. And for taking 164, recording 164.
No, I think Sangeeta's question is premised on cognizance has already been taken. Cognizance of the offence and not the offender. And therefore, post-cognizance, will it lie before the magistrate or before the special court appears to be the question. Am I right, sir?
Yes, precisely, sir. Precisely.
But the application was filed before cognizance.
Before cognizance. Whether that application can be carried forward to post-cognizance stage.
Suppose it was filed, and which did not come to the notice of the court.
No. It was it was pending consideration. Pending consideration.
The question will be, though filed before cognizance, post-cognizance, whether that application can be considered. I believe
after the cognizance was
even though filed pre-cognizance. Now, if pre-cognizance it was filed, as Ramkumar now said, based on the consensus which appears to have been reached, it should have been sent to the CJM.
Yes.
Now that cognizance has been taken, can the special court invoke its powers and
under section 307?
Right, that's the question.
But by carrying forward the application that was filed earlier.
The practical way will be to dismiss that application and ask for a further application.
There is no legal impediment. There is no legal impediment because it's a question of exercise of power, which is invested with this trial courts.
Mathew, cannot the special court dismiss that application and ask the prosecution to give another application?
Yes. I'll with the liberty to file an application dismissed.
Sir, why waste one stamp?
No.
I know stamp is
No. My concern.
This can be a trick played by advocates. Just before this trial court take cognizance, an application is filed on the previous day of this pre-cognizance day.
This is prosecution of file.
Prosecution has to file it. No.
Accused cannot file it.
Accused cannot file.
Oh, right. Prosecution has filed. Accused also can file, provided
Sponsor.
Petition or on the date of the
Exactly. That's the precise question.
How many times it has been held the court has the power to consider it, and therefore is that
no. My concern, sir, would be is because the rights of the co-accused stand on different footings. Are separate, are different when it is considered under section 306 and 307 are separate.
No right is conferred on co-accused. What right is
No,
conferred on
that is the general that is the general convention that is followed. I can raise my grievance if it is considered under section 306. I have the right to cross-examine. If it is considered under 307,
you have no right to cross-examine.
No, you don't have a right.
You have no right to cross-examine.
That also is
The section
concluded now.
306.
That's concluded. Is it
Concluded.
Monu Surendran, Justice Button's decision.
Supreme Court overruled it.
Monu Surendran ka poi.
But I have
Monu
become
Surendran ka
wiser.
poi.
I have become
Monu
wiser.
Surendran poi.
Supreme
Alla
Court
Tadiyandavada Nasir. Alla Tadiyandavada Nasir was reversed by Justice Hariprasad. Full bench. Heading a full bench.
Holding what? No right.
Alla,
See, my
Allah,
the decision. No, adalla. Tadiyandavada Nasir. What was
that
the
was
question?
not this question.
That was not the
Alla,
question.
idalla. It was in Monu Surendran.
Monu Surendran said they have got the right. Justice Bhatt said his own decision is per curiam.
That was reversed. That was reversed by the Supreme Court.
That is
Surendran.
Yes. Justice Bhatt's decision was reversed by the Supreme Court, holding that here examination officers does not mean that it is examination as a witness. It is just recording the statement, nothing else.
And it says he shall be examined as a witness.
Witness. It is not a witness. It is not as a witness actually. It is not as a witness because examination of witness can take place only after cognizance is taken. There is no question of examining a witness before that. Only during trial. He is not being examined as a witness. Though the term used is a witness because that word is used in section 161, I think, 160 or 162. Then another section also that witness is used. It is a misnomer.
Mathew. Yes, unlike 200, 202, the Supreme Court has held in two decisions that if the witnesses are examined and after the post-process stage, in a private complaint warrant trial, 244, 246.
Right.
The accused have a right to cross-examine.
Right to cross-examine.
Yeah. So supposing the magistrate taking cognizance and committing the case examines the approver after issuing process to the accused.
So the
are
difference
they not
is that the
entitled?
Supreme Court has that it is neither an inquiry nor a trial. That is the difference.
That was the view by Justice Padman in Re.
That is
CJM
approved by the Supreme Court. It is neither an inquiry nor a trial. So there is no question of this
cross-examination.
It can be done even in the chamber.
Yes, it can be done even in the chamber.
By merely saying examination as a witness, cross-examination, right to cross-examination does not automatically follow.
Does not.
Yes. That is the dictum in that.
You are not trying a case. You are not recording evidence of a witness. You are only recording statement of a person, an approver.
But does it mean?
But after process, did not. After the accused appears, after the appearance of the accused, should he not get a right of cross-examination?
How can he appear before this cognizance is taken? He cannot appear.
Magistrate taking cognizance and committing the case. Sessions trial.
Okay.
First cognizance. First cognizance
because he is not entitled to try it. There is no question of trial. He cannot examine any witness.
No, he has to examine. In a case triable by a court of session,
he has no power to try the case.
That is true.
So he is not examining any witness during the trial. It is just like the declaration, or it's just like 164.
Right. That is the comparison used.
That may be the distinction.
That is a correct distinction.
It's not a trial.
Not a trial or inquiry.
Nor even the recording of a statement of a witness stricto sensu.
Stricto sensu. That is because
but then Abraham Mathew, one question. Suppose after commitment, the sessions judge gives pardon to one accused. Then
406, 306, 4A is not there. Will not apply.
No,
not there.
It cannot be complied with. That's all. It does not affect the right of this accused.
Does not apply.
It does not. What right is affected? No right of the accused is affected.
He gets a right to cross-examine in trial.
Correct. At the time of trial, as a witness.
Only one examination.
One examination, right.
During trial. That is why the same court granting pardon is trying in under the 307.
307.
Whereas under 306, the court granting pardon cannot try.
Cannot try, correct.
All right. That's all. I will
Let me try
as we come to the end of
let me try to edit my article, revise my article.
In view of the inputs and discussions, it will be definitely. So I would,
before you conclude, Shyam, I must say, I really appreciate Justice Ramkumar's efforts. Actually, it's a very concise, very erudite paper which I read, and I thought I could not resist myself from not attending today's function. I'm really thankful to Justice Ramkumar for the good efforts he's making in the cause of law, even after the retirement. And I understand he was sick, COVID-stricken, but still he did all this. Thank you very much, Ramkumar. You really deserve appreciation of all of us, gratitude of all of us that you've done that. I think I'm better informed on 306 than I was at any time earlier. Thank you very much for that.
We all endorse the view.
Yes, exactly. It's a treatise on 306, no doubt. Pardon.
That is right. That is right.
Sir, a wonderful evening, a wonderful Saturday evening, I'd say. And as we come to the end of the 268th session, may I request Premraj to offer the concluding remarks so that we can wind up the session. Prem, over to you.
Now, I would just pass the mic on to Mr. Dilip because I had an intro session. So let Dilip do the concluding session.
Dilip is here.
I may not be able to, speak on this subject because I'm not conversant with any of these things. But having listened to every panel members and their wisdom over the subject and their exposition to various nuances of this provision, I accept that, I feel that I am truly enlightened by the presentations given by everybody. And in fact, Harshad Mehta's case, I think 30752, it has been committed to the special court.
No committed.
Section 9,
no
committed.
But section 9 of the special act says that it's a court of sessions. Section 9 of
but
the
it can take cognizance on a police report or on a transferred case. It can directly take cognizance, no committed.
Yes. So that court is empowered to give tender pardon, right? I am not very much.
That is what they held, even during investigation.
Investigation. I don't know exactly what.
But sir, the only problem that arises is Pascal Fernandez was considered in Harshad Mehta. Now, that's the only difficulty.
It's
one judge goes against another. Absolutely, co-equal benches. Co-equal benches.
Co-equal benches. So, but, actually, no valid reasons are given as to why it should.
It's not that valid. It's not that valid reasons are given. The thing is that it's not conducive to much clarity.
Because there is a decision by Justice Dr. Chauhan saying that both are identical. Provisions are identical in the matter of entering pardon.
True.
That is that Ashok Kumar Agarwal versus CBI.
CBI, 2013.
2013.
13 decision.
Correct, sir. So, sir, as we conclude, let me first thank Justice Anand Venkatesh in absentia, because it was in fact he who was instrumental for rather instigating Ramkumar sir to have a debate and a deliberation on this topic. And we had a session earlier. This is the second part, and I'm sure that all of us are benefited. Let us also thank Justice Basant, Justice Hariprasad sir, Justice Nagamuthu sir, Justice Prakash sir, Justice Abraham Mathew sir, and all of you wonderful participants for being part and parcel of the 268th session. And tomorrow in the 269th session, we are on another topic, intellectual property litigation and its interface with competition law. Introducing the topic will be Dr. Srikanth Parthasarathy, and the speaker is Advocate J. Sai Deepak of Supreme Court. So till we meet again tomorrow, let us go home empowered and enriched for having spent a wonderful Saturday evening discussing, deliberating on a wonderful topic with such a wonderful panelists. I would say that no literature or no reading of any of these topics otherwise would have empowered or enlightened us than listening and being part and parcel of this session today. Thank you all for being part and parcel of this wonderful evening. And thank you, Ramkumar sir, again for all the efforts being taken on this one. Thank you. Thank you very much.
Thank you, friends. Thank you, brother.
Thank you. Shyam, what about
lively
persons?
participation?
Shyam, what about persons who are already at home? You said that everybody can go home because we are already.
No, sir. I mean, back to the chores of the home. I mean,
home means to the other room.
In the literal sense, right?
Yes, in the other rooms of the house. to the other rooms.
At least you can communicate yourself from the computer. You can go offline, sir.
Okay, thank you. Thank you very much.
Okay, then. Thank you.
Tomorrow, 11:30.
Thank you so much.
Thank you to all. Good night.
Thank you.